with more states joining the suit filed by some of their counterparts at the Supreme Court against the federal government, all eyes are now on the Apex Court ahead of the hearing on Wednesday, February 22nd. Now let's discuss this controversy and the imminent constitutional crisis this might create. And we have joining us in the studio a senior advocate of Nigeria, Sam Kabo. Good morning, and thank you for joining us on Daybreak this morning.
Thank you for having me.
All right, so can you kindly explain to us the legal circumstances surrounding the suit instituted by the state governments, against the federal government in the Supreme Court?
Okay. You mean the one that was started by
the Kaduna and Kogi states, yes.
And Zamfara?
Yeah.
Okay. I think the grounds or the case they put before the Supreme Court is that the withdrawal of the 500, 200, 500, 1,000 NAIRA notes as legal tender is unconstitutional and against the provisions of Section 20, subsection 3 of the CBN Act. I think basically the crux is that the notice given by the Central Bank on the directive of Mr. President does not meet the requirement for reasonable time that is specified in that provision. I do not think, and I think I have read the papers that they filed, that is the originating summons they filed. I've also read the affidavit in support of it. They are not challenging the policy per se to say that the policy is not good. What they are saying is that the way the policy was announced and implemented, that is from the beginning to the end, does not meet the standard of the law. That's their case. And I think they took the case to the court, to the Supreme Court, because they believe that they have a dispute, and the dispute is between the state and the federation. And the law is that the court that has original jurisdiction over a dispute between the state and the federation should be the Supreme Court. But there's something that I need to explain here. The federation does not constitute the federal government. The federation constitutes the totality of what you call the Federal Republic of Nigeria. And I think the person who personifies that entity as a human being, if the federation is to be reduced to a human being, is the president, and not the government, and not any arm of the government.
Okay. All right. So let's look at the legality of issues. The Supreme Court gave a date for judgment. Then they adjourned it again, and after that, they released a statement saying that the monies remain, the notes, banknotes remain illegal tender up until the time that a substantive ruling will be given on that. A couple of days after that, the president came out and said something totally different. Now, what supersedes what? And is the president in right by virtually going against what the Supreme Court actually said? Is it that not grounds for contempt?
I will answer it this way. I'll be very cautious. Like we all know, the matter is still before the court.
Exactly.
And we are not supposed to go into the substantive aspect of it. I would only more or less talk about the procedure and the processes before the court, and what happened before the court. There was a dispute before the court, and the plaintiffs then sought for an interim order, that is an order staying, or if I may call it, pause the implementation of the deadline from the time they instituted the case, I think about the 8th of September, to when the defendants that is the defendant, that's the Attorney General, would have an opportunity to respond to the application on notice they have filed and served him. That application on notice is also going to be asked for the same relief, but this time around is for an order, an interlocutory order between when that application is heard between them, when it would have been contested between them before the court, and when the case is finally determined. That was the order given. So it was expected that that application for the one on notice for the interlocutory order would have been heard on the 15th, but it wasn't heard on the 15th because other parties had joined, and the rule is that once parties join a fray or a dispute or a case, they have to be given the opportunity to also file their own contribution. They will also have to be served the originating processes. The originating processes too would need to be amended to reflect their participation in the suit. That was why the matter was adjourned. So what is coming on the 22nd is the hearing of the motion on notice, which is seeking an interlocutory injunction restraining the federal government from implementing the deadline pending the determination of the suit. Or the court could say, okay, I hear both. Since you already have your processes, I will hear both and give a date for judgment. Let me recap. The first order was given was an interim order to say, don't implement the deadline pending the determination of the application on notice. And the one that was given, that interim order was given ex parte. It was given without hearing the defendant because of what? The shortness of the time that the federal or that the central bank had set for the implementation of the deadline. That is on the 10th. It remained only 2 days. If they had to serve and wait for the defendants to come and contest the issue, then they would have had a fait accompli because the deadline would have elapsed. Yeah. So they give them that, and the law allows that if you have this sort of a nature of a dispute where the rest, or that is the subject matter of the dispute, is subject to some sort of impairment or peril, it is reasonable for the court to protect it. You know, that was what was done. So I would not know whether what the federal government or Mr. President acted upon is the belief that since the interim order, the adjourned date was on the 15th, then the interim order would have lapsed, meaning that the interim order asking for a stay had elapsed, and therefore he had what? The power to do what he wants to do, irrespective of the fact that there is still the case before the court, asking him to stay action on the deadline. If that is the thinking, I would say that in itself too may not be well advised, because the position of the law is that once you have a dispute before the court, and the dispute is about a specific subject matter, this time around the subject matter is about what? The deadline. The deadline for the cessation of this 200 and 500 and 1,000 naira notes being legal tenders. That is the deadline within which you can still exchange them for goods and services, or you pay debt for them. That is the dispute in court. The law is that once you have that dispute, you should, the two parties should not do anything that would affect that subject matter in any guise. And this has nothing to do with the merits of the case before the court. It is not the business of the court at that point to say, I can foresee that this case has merit or no merit. No, the law says, even if it's on the face of it the most frivolous or vexatious, as we will call them, case, stop. Because the authority over that dispute is the court before whom the matter is presented. Not for you to pick and choose an aspect of it to obey. This is why I think people are rising up in arms against Mr. President to say, even though you sounded benevolent, that benevolence in itself is an offensive patrimony. You patronize the court in a sense that you say, okay, since we have this matter in court, I can meet the court halfway. No, you can't do that. Your business is to say, okay, now that the matter is in court, let us wait. In any case, there is nothing fundamentally crucial that would prevent you from waiting for the court to decide. Because in any case, your Attorney General has already filed papers challenging the jurisdiction of the court. And that issue is before the court. And if he succeeds and the court rules that, hey, I don't have jurisdiction, that ends it. And even if he says, I have jurisdiction, but on the merit, there is no merit before the court, that ends the case. But as it were, what if the court now holds that it has jurisdiction and the case is meritorious? What happens? You've already what? Inflicted a harm on the polity and on the people by what? By your own action.
Okay, so what about the controversial broadcast by the Kaduna State, governor, overruling what the president has actually said?
That's another kettle of fish altogether. And I think my earlier response to it here is that there's a sign of anarchy. Two wrongs don't make it right. Of course, Mr. President, like I said, my thoughts, not finished thoughts, and subject to what the court would say, is that Mr. President was wrong to have tampered with the subject matter of the suit before the court. But it is not in the place of Mr. Governor to say, hey, don't mind Mr. President, mind the court. The court is not a party to the case, and the court has done its bit, and whatever happens there has nothing to do with the court. So it is not right, and it's dangerous for us to have the people being confused with those sort of two directives, because at the end of the day it will trickle down to some other disputes as well. Tomorrow somebody could say, since you do not obey the court, I will also not obey you, and I want to do something on my own. That's taking the law into the hands. No, you can't do that.
All right, I have a question burning at the back of my mind that I actually want to ask, but that will be after we take this break. Right now on Daybreak, do stay with us.
Hi, my people, reason this thing now. When PDP day, our country be safe. NAIRA strong, economy they grow. Fuel, 7 naira, rice, 8,000. Our life in better, oh. When change people come, no work, no food, economy forgotten. I got borrow, banditry foot down, Japan left and right, Sapa up and down. No need to gamble, say choice. PDP don't come, say choice. We cover Nigeria, say choice. We don't tire to suffer, say choice. Experience mind, say choice. We don't want experiment, say choice. Get them right, say choice. go ahead. You're not the only choice, so safe choice.
Vote the safe choice to recover Nigeria.
PDP! Power to the people!
Now, PDP Presidential Campaign Council sponsored this message.
That's great.
Welcome back, and thanks for staying with us on Trust TV's Daybreak. And we're actually talking about the legal issues surrounding the NAIRA redesign policy, the case between the Supreme Court, before the Supreme Court trial, between some states of the Federation, of course, the federal government as well. So before we went on that break, I was actually saying that there's this question I wanted to ask. And I know you have to be careful how you answer these questions, because you just said it's a matter that's before the court, and we should be careful how we do that. So my question now is, the Supreme Court has said one thing, the federal government has said another, and the date for determination of this case is the 22nd. So what happens now on the 22nd if the Supreme Court says we should extend this deadline, which the federal government has already said it's not going to? So doesn't that leave us in sort of a legal limbo?
No, it does not. You see, this is the way the court system works.
Okay.
If you come before me, you're asking for a declaration. My business is to either grant you the declaration or decline. And I'm not going to look at the facts after the process you have before me. Because the court is presumed not to be out here with us to know what is happening.
Okay.
The presumption is that it has a case before it and facts supporting that case.
Okay. So as far as
That
the
is
court is
what
concerned,
the
nothing else
court
has
is
happened.
concerned with. It's different from some other disputes. This is about a declaration to say what he did, was it right or wrong? Did he meet the law or did not meet the law? That is what is going to determine at that point.
Okay.
It's not going to say, but the horse has already left the stable and therefore this is an academic destiny. No, it's not. But for some other disputes outside those for declaration, yes, you could say the court should not act in vain because this is becoming an academic issue. Here it's about the court interpreting the action against the law and say whether or not it meets the standard of the law. Mind you, it is not just speaking to that particular case, but given an interpretation of provisions of the law, which is its own job. Once it has given that interpretation, it guides us as lawyers and the public as to how to understand that provision. So when next some acts are taken in the name of that provision, we the public, wherever you are, you already have a sixth sense as to how to judge that very particular act. To say the Supreme Court has said, if you did this, that does not meet the standard of the law regarding that very particular provisions. And the issue of whether or not Mr. President is in contempt or whatever it is, the court is not going to be activated by any other thing, by rumors or by public outcry, but by what? The parties. The party who took the matter to court, the plaintiff, who is the aggrieved person, is the person who has to activate the process. If he files papers for contempt proceedings and he proves the fact that indeed Mr. President has acted in contempt of the court, then the Attorney General will be cited for contempt. Mind you, cannot bring Mr. President to court. A sovereign cannot come to his own court. You are suing him as what? The embodiment of the status of the federation. So you don't bring him to court. You bring the Attorney General. That's what the law says. And that is why it's the responsibility of Mr. Attorney General to advise Mr. President accordingly. And let us also get this thing straight. I've had some commentators, some commentaries talking about and making conclusions regarding the merit of the policy. No court has any jurisdiction whatsoever to delve into the merits of a government policy. That is not his business. The people who are to tame that policy are the public, the people, not the courts. But what the court has power to do is to check whether or not the policy was made in accordance with the law. It's the procedure that the court is concerned with. So if you go to town crying that everybody should know that this policy is bad, or you go to town to say that everybody knows that this policy is good, that is not the business of the court. The court does not have that power. Because what? You are given a responsibility. Your responsibility is that of interpretation. The responsibility to act for and on behalf of the state in respect of all executive matters is that of Mr. President. If by his own wisdom has decided to to fashion and implement a policy, it's for the people to cry him down, not for the court.
Not for the court. Okay.
Okay, now, some have actually accused the Supreme Court judges of abdicating their responsibilities, you know, and adding to the confusion.
How?
Yes, to the confusion people are mired in, you know, saying that they would have as well, you know, finalized the judgment on the 15th of February instead of, you know, dragging it.
That's unheard of. They could never have, because they don't have that power to do so. They have, you see, the symbol of our judicial process, our judicial system, or adjudicatory system is that of a blind woman. You are presumed not to know what is happening out there. You understand? The court had a case before it, and that case before it is against somebody. Those two parties have to come and slug it out before the courts, for the court to believe one and disbelieve the other. That is his own business, to say, from our own understanding of what the law says in these provisions, this person is right, this person is wrong. That is his own business. So what was presented before it on the 8th was the case, and as at that point, it has no power, no authority or jurisdiction, as we say, to judge it there and then, to say, I'm part of Nigeria, I'm part of this place, this is my judgment. No. You become what? Both a prosecutor and judge in your own cause. It is not their own cause. The case was brought before them by a litigant against another litigant. The first litigant has asked for a relief which they can give, to say, now, before we hear this matter any further at all, these are the facts. If you do not stay it, then this case would have been made nonsense of by the time we come before you. The law says you can do that. And they've done that to say, between this time and this, Mr. Federal Government, stay. Then that order does not go into the merit of the case and does not in any way adjudge the policy in any form. It just says, stay till I hear somebody who has brought a grievance before me concerning that. Even if that grievance was brought by one notorious non-entity out there, as long as he has the capacity to sue, it's not a mad person. It's not somebody who is convicted or whatever, who is serving a jail sentence. That case will be heard. It's not going to go about the merits. And that's what the judge did. So there is nothing that complacent there. If for anything, they did their job. And let's get this straight. The judges would always and for all time only say what the law is. The effect of the law, that's your business, you the litigants. How it affects every other person, because they are not meant to make judgment using their own intuition or their own experiences. If a judge witnessed something and the matter is brought before him, the worst he can say, because of my nearness to the fact, I will recuse myself. Let some other person judge it. I would rather want to be a witness in this case because what? I saw it. But beyond that, as long as you sit down and you hold the gavel as a judge, you are blind.
Right.
You could be agonizing there to say, this person, this clever rogue is getting his way. You have nothing to do but what? To give judgment according to the evidence before you. And most times, I pity them. A question is brought before them, they make the judgment. They kill them, they curse them, they abuse them, they've sold out, they are rogues, they are bandits. Unfairly. And most times it's come from lawyers who have turned activists, who make money out of the rostrum of giving the guys that they are for the people. There is nothing as cheap and easy as criticism. I have been a writer, a columnist from 1998 until 2019 when I said, okay, let me stop and face my application. I know what it is, how sweet it is to criticize. Easy. I write my back column. Within 2 hours, I've sent it. If I forget, the editor says, I have not seen your material. I say, I drop whatever it is. In 2 hours, it's there. Easy.
All right. Well, we look forward to
so easy
to the Supreme Court judgment on this matter, and we.
But mind you, on the 22nd, it's not going to be a judgment.
Yeah.
They are going to, if at all, if there are no other applications, if there are no other impending or pending matters, they are going to hear the issue for the interim injunction.
Okay.
If they hear it, they could also say, we've had this. Let us now hear the case.
Yeah, let's hear the case.
You understand?
All right.
There is also the issue, what they are even going to hear before even hearing the one on the issue of the preliminary objection. Because that is a threshold issue. The court must jump that hurdle first to say it has jurisdiction, and that the parties who are before it have the locus and they have a cause of action.
All right.
Those issues have to be determined first before you now go to the issue of the interlocutory injunction and the final the case on the merits.
Okay.
Once the papers are in, the next, if they hear this one by that sequence, the next date may before the judgment.
All right.
Ruling.
Well, we look forward to all these processes coming to a conclusion, and of course, we make some headway concerning this particular policy. Senior Advocate of Nigeria, Sam Kagbo, thank you very much for coming on the program, and we appreciate all these legal insights you've given us. And of course,
thank you very much.
We look forward to having you again to determine certain issues again.
Anytime.
All right.